place our usual conference season. And to do that, we had to get together a stellar cast. And I can tell you we've got a stellar cast this evening to discuss what is a very interesting subject, and that's the influence of the narrative in international criminal trials. First of all, I'd like to introduce you to Professor Margaret de Guzman, Meg de Guzman, Professor at Law at Temple Law School. She is also the co-director of the Institute for International Law and Public Policy. She's speaking to us tonight from Philadelphia in the US. She is a specialist in all aspects of international criminal law. And by that I mean IHL, human rights law, transitional justice. She has written extensively, and she particularly focuses upon questions concerning the International Criminal Court. And she was a contributor to our next speaker's book, which was The Arcs of Global Justice, Essays in Honor of William A. Schabas, a very distinguished body of work. And I'll now introduce Bill Schabas, Professor Bill Schabas, OC, Order of Canada, and I know he's very proud of that, and also a member of 9 Bedford Row as a door tenant. When I invited him to become a door tenant, he asked me, first of all, what was it? And when I explained that it was something that Nelson Mandela had in his honor down in the inner temple, he said, well, if it's good enough for Nelson Mandela, it's certainly good enough for me. Bill is a very important influence upon international criminal law because he's authored many eminent textbooks, well known to students as well as practitioners. He's also been a contributor to UN projects, the Commission of Inquiry into the Gaza War, where he had a role, but more importantly, in relation to what we're dealing with tonight, and I know it's going to come up, he was a member of the Sierra Leone Truth and Reconciliation Commission, where narrative was a particular focus. After Bill Schabas, we have Dr. Mark Ellis, who is the Executive Director of the International Bar Association. Prior to joining the IBA, he was a member of CELI, which was the Central European and Eurasian Law Initiative, which was a project run by the American Bar Association. Why I mention that is because in 1996, I got an invite to go to The Hague to instruct the Dutch law team involving Professor Vladimirov, and now His Honor Judge Ori, in the art of cross-examination and case analysis for international criminal trials, and in particular, the Tadic case, which was the first case to be heard at the ICTY. Mark Ellis was very much the organizer of that project and very much heavily involved in the initial establishment of the International Criminal Tribunal for the former Yugoslavia. So Mark and I go back a very long way, too many years to mention, and he has also written upon subjects of international criminal law, and he was heavily involved in the Iraqi tribunal as well, which you remember took place. So having introduced the background to my speakers, I'm now going to turn first of all to Meg de Guzman, Margaret, for you to give us some thoughts about our chosen subject for this evening's webinar. Meg, thank you.
Thank you so much, Stephen, and thank you for including me in this really important discussion. The focus of my remarks will be on this concept of shocking the conscience and how the narrative around that idea has influenced the development of international criminal law and and sort of the dangers that the narrative poses for international criminal law's ability to do justice, in particular with regard to fair trials and defendants' rights. So this is a question that I've been thinking about for a long time, and that is to say, this idea that international crimes are the worst of the worst, are crimes that shock the conscience of humanity, is an idea that is very much pervasive in international criminal law, both in terms of the discourse among supporters of international criminal law, even critics of international criminal law, and in terms of the jurisprudence. So courts will frequently cite this idea in order to justify various kinds of conclusions, various decisions related to jurisdiction, related to admissibility, related to defendants' rights, sentencing, and so on. And yet it's an idea that is very poorly understood and frankly, very little examined to date. So I recently published a book on it, which is entitled Shocking the Conscience of Humanity, Gravity and the Legitimacy of International Criminal Law. And in the book, I start by examining the idea itself and noting that it was not inevitable that international criminal law come to be focused on this idea, right? That international, there was a kind of a turning point um, right around the time that the Rome Statute was adopted, where international criminal law could have included what were then called treaty crimes, crimes that involve more than one state, that cross borders, crimes like drug trafficking, for example. There was heated debate in Rome about whether to include those kinds of crimes. And even again at the review conference in Kampala 10 years later, the issue was revisited. But each time it failed. And instead, what have come to be known as atrocity crimes are the central subjects of international criminal law. Why is this problematic? Well, although it is true, of course, that many of the crimes that international courts deal with are very, very grave in whatever sense one might consider the concept, it is not always the case. And it is not generally examined in any kind of detail when the idea is used to reach conclusions. So in terms of for example, war crimes can be individual crimes by individual perpetrators unconnected to any kind of systematic commission of crimes. And they can be of relatively low impact on victims. Nonetheless, war crimes are lumped in with crimes against humanity and genocide as atrocity crimes. And the crimes treated as a package lead to conclusions about things like defendants' rights. So I am only supposed to talk for a few minutes, so I'll just give a few examples. And I know that our discussion is going to focus on fair trials. But what are some examples of ways that courts use this concept of gravity or of crimes shocking the conscience of humanity to limit defendants' rights or limit the defenses that are available? Some examples include many of the tribunals have had a relatively low burden of proof, at least I argue in the book, in terms of the kinds of evidence that is admitted and the way that courts reach conclusions based on the evidence. Anonymous witnesses are allowed, evidence that is illegally obtained, evidence that would not typically be admitted in many domestic systems is often admitted on the grounds that these are such horrible crimes that this kind of evidence, despite its potentially less reliable nature, it ought to and is admitted. Another example is that trials take tremendously long, and this violates a right to an expeditious trial, arguably. But again, courts will justify the length of the trials based on this idea of these crimes being extremely grave and the need for sort of very, very lengthy and involved trials. So in addition, and I'll just close with this, there are many decisions that justify limiting defenses. So limiting the availability of immunities, limiting the applicability of amnesties, taking a very narrow view of the principle of legality in deciding that certain crimes that haven't really existed in any concrete form can nonetheless be applied against particular defendants, limiting duress, superior orders, statute of limitations. And so my argument is not that these decisions are necessarily all wrong, but rather that we ought to interrogate this idea of crimes being particularly grave and be careful about how we apply it in order to avoid unfairness in international criminal law. So I will stop there and look forward to the discussion. Stephen, I think you're still on mute.
Yeah, there we are. I should never press buttons, of course, you all know that. Thank you, Meg. I'm going to turn now to Professor Schaebas. Meg's point being quite clear there that and this is often the case, the bigger the allegation, the more likely people are to believe it, and the more difficult there are for rights of an accused to be maintained and supported. What's your perspective on the narrative within international criminal trials, Bill, in 5 minutes?
Thank you, Stephen. Well, trials, international criminal trials, and international criminal tribunals, whether we like it or not, are often, maybe not always, linked to a message, a narrative, an agenda that has a political dimension to it. Whether we go back to 1919, the idea that Kaiser Wilhelm started the war and that the Germans committed all the atrocities, to the narrative in the Second World War about Nazi atrocity and about the aggressive war. We can see it today at the International Criminal Court. Later this week, we're going to have the judgment in the Ongwen case. That's part of a narrative about civil war in Uganda being the result of the evil Lord's Resistance Army. There have been no prosecutions against the government forces of Uganda for anything, any atrocities that were committed. It's part of describing a conflict. We have an ongoing trial at the International Criminal Court in the Al Hassan case, which is the narrative about the nasty Al Qaeda affiliate that took over northern Mali and started to persecute the population. So there are narratives there that are associated with them. What's interesting to look at is how the courts deal with this. They don't always prove the narrative. So they come with a narrative about a conflict and they actually don't deliver the goods. And at the end of the day, we're not sure whether they got the narrative right. Sometimes the narrative is sort of imposed on the court afterwards. One of the ongoing experiments, the new ones in international justice, the Kosovo Specialist Chambers, began with a narrative about organ trading, about Serb prisoners being murdered in Albania and having their organs taken off them. And I think a lot of people still think that's what the Kosovo Specialist Chambers are doing. That narrative has been dumped altogether. And now those chambers are focusing on something significantly different, although the targets are the same. The acts are quite different. You mentioned in your introduction that I had served on the Truth Commission for Sierra Leone, and There was a theory early in the work of that tribunal that came, I think it was first announced by the president of the appeals chamber, Jeffrey Robertson. And Jeff said in a ruling that he made that he thought the relationship between the Truth Commission and the Special Court for Sierra Leone would be that the Truth Commission would develop the overall narrative and explanation of the conflict, and then the Special Court prosecutions would deal with individual cases within that framework. But that's not what happened. What happened was that the Truth Commission developed a narrative that was quite different from the narrative that was developed and emerged from the work of the Special Court. So the Truth Commission's report, which came out in 2004, told the story of a conflict in Sierra Leone that was the result of a corrupt elite that had ruled the country for 30 years and that had provoked civil war by desperate young men and women trying to fight to overthrow it. Ultimately, they were hijacked by people with perverse objectives, but that was essentially what that conflict was about. And the Truth Commission report said, this business that's all about diamonds, not really. That's not what the Truth Commission found. And the Truth Commission said that the rebels were after the diamonds only because the government had them and was using it to finance their side of the war. What did the Special Court do? It pursued a narrative that focused on, initially on the diamonds, but more generally on the idea that there were external forces to Sierra Leone that had sort of imposed the war on the people. And of course, the main culprit then became the head of state in a neighboring country who'd never even set foot on the territory. And the idea was that he was going to be the supreme villain. I'm talking about Charles Taylor. Finally, they couldn't really prove it. All they could do was establish that he was an accomplice, and it didn't really establish the narrative. But it's interesting that these two institutions that were supposed to have a very a kind of a synergy between them and a compatible view of the conflict ended up actually going in different directions. I think that's one of the interesting facets of the narrative as well.
Yeah, thank you, Bill. I remember the organs issue coming up in the Milosevic case and being served during the trial with all this evidence concerning organs and then being carried north from Kosovo into Serbia, allegedly. And I couldn't make head nor tail of it, nor really understand what it was doing in the case. And it didn't seem to even have any evidence to back it up, but it occupied a lot of court time. But it was interesting to hear your point that it was part of the promotion for the Kosovo Special Tribunal. Thank you. Mark, the narrative and your perspective from it, because yes, you were there right at the start with the Yugoslavia Tribunal, which very much took as its sort of following on from the Nuremberg Tribunal, if we go back that far in time.
Well, it's fascinating because listening to Meg and Bill and talking about the narrative and who are the players in the narrative, who has part of not only responsibility, but the opportunity to create that narrative. And 2 years ago, three of us, Professor Linda Carter and Professor Charles Jallow and I, started looking at this and published a book in an area where we focused on the important role that civil society is playing as part of this narrative, and particularly in the area of amicus curiae briefs. And this was really fascinating in the sense of how these were being used to engage with the courts, which were initially doing so in ways of just providing information that was kind of beyond the interest of the parties themselves. But something started shifting, and it started mostly in the domestic experience in the United States and Canada, where these amicus curiae briefs started to take on a source of, or become a source of really kind of partisan advocacy. And this started moving into the courts, and all of the international courts have, under the procedures we found and the procedures and evidence rules, the ability for outsiders to play a role through these amicus curiae briefs. either in person or predominantly in writing. And it was controlled by the courts. The courts could even could invite civil society through NGOs, or NGOs could seek an opportunities to submit. And this started becoming very important. And it started expanding with these courts beyond individuals, but actually involving states and organizations and individuals in seeking their views in how this narrative of a case is going to be defined. And you see it in the ICC, not as much as the other cases we found, but in the ICC has been fairly active on that. The Bimba case with Amnesty International played a very important role in the amicus coming in on superior responsibility. The Gbagbo case, that too, where you had individuals invited to talk about, submit their opinions on what the concept of a tax meant, even allowing the African Union to submit a brief in their views. Stephen, you'll remember back in the Tottage case early on, where the ICTY opened up the opportunity to listen to outside views, including, in this case, the United States government was permitted to come in to talk about, of course, the jurisdictional issue, which was crucial for the ICTY at the initial stage, and about 20 other individuals as well allowed to come in. But it was the ICTR that I think, in the sense of thinking about a narrative and the role that outside individuals, entities played, and that had to do with the issue of rape as an international crime, and particularly rape in regards to explicitly to genocide. And the Akayesu case was, to me, the most important example of the role of outside influences, outside views in trying to influence the narrative. Because in this case, it was in fact civil society through NGOs that pushed for the court to look at rape as part of the indictment that the prosecutor had never included. I think it helped that we had a woman judge on that court that helps us reaffirm the necessity of having balance with Judge Navi Pillay on there. But the fact that one NGO and probably about 40 other human rights organizations were involved with pushing the court, advocating to the court on a narrative that had not even been considered, I think was really crucial. We saw the same thing with the Special Court for Sierra Leone, probably the most active court in accepting outside views through amicus curiae briefs. And the Charles Taylor case was a big example of where there were submissions that came in that became quite important in the decisions of the tribunal. And we even see it in Cambodia with the Extraordinary Chamber of the Courts of Cambodia, particularly with the joint criminal enterprise concept. That too got really merit through the court's interest in hearing through the briefs the views of outside NGOs, the outside experts as well. So when we take a step back and again look at this within the narrative, I think we really need to understand the important role that these briefs, the amicus curiae briefs, have played, and the briefs, particularly from civil society. And I think that's positive because it has allowed civil society to engage in this narrative. And I think that has been very positive for international justice at large.
Yeah, we're going to go into discussion, but there's a question that's just popped popped up on what you've said there, Mark, and I'll put it first of all to Bill and then Margaret, if I may. Mark, there of the view that providing narratives can be helpful for a court, but I'm bearing in mind what Margaret said at the start. But Bill, first of all, looking at it from a historic situation and your experience, has this development of narrative been helpful for the truth? I think Mark is looking at it from the perspective of a voice and allowing engagement by other areas that may be interested in a particular case. But where does it take the truth and justice? What's your experience?
Well, I don't know if we can equate truth and justice. Anyway, that's another question. But one of the, sometimes the narratives, well, the question, and I think this has been raised, the question on the chat now, it may influence the fairness of the trial, because there's a narrative that's so entrenched about who the villain is that it really has become extremely difficult for that person to benefit from the presumption of innocence in a trial. And we've seen this at the ICC, where civil society is also extremely disappointed when somebody gets acquitted. And they view that as a great setback and it's a setback for the narrative in a way, but it's not a setback for justice when someone's acquitted. It's a proof that justice is working. And I think that's one of the challenges that we have to confront about this. I think that sometimes the other thing, and I was alluding to this referring to this in my remarks, is that there is a narrative that prosecution doesn't really prove. And yet, I don't know whether it goes away. I mean, people talk about the Nuremberg trial, and I think most people think the Nuremberg trial is about the Holocaust. And there are some pages in that judgment that are about the Holocaust, but most of it is not. And that's not really the narrative. Robert Jackson's narrative was one of aggressive war. But today, most people would be surprised to learn that. Students of the subject obviously know better, but they would be surprised to learn that about the Nuremberg trial. Mark Ellis referred to the issue of genocide and rape, and of course we had that as an important part of the narrative at the Yugoslavia Tribunal as well. I don't think the ICTY really developed that. I don't think that does emerge from there were some convictions of rapes, of course, there were some, but not the way it was anticipated back in the 1990s. So then the question arises, and this is when the prosecution fails to develop the narrative and prove it, does it mean that the narrative was false to begin with? Or does it mean that the prosecution failed to do its job to bring out the narrative? And I think that that's a challenging question for us sometimes.
Yeah, Margaret, turning to you now, because I remember when we first started Tardich, and I'm sure Mark will agree with this, and I know it's something that you've studied. We were all very concerned about a fair trial, and Amnesty contacted me, Human Rights Watch contacted me, everybody involved around the ICTY at the start wanted to make sure there were fair trials. They were very much thinking back to Nuremberg and the criticisms over Nuremberg being the military trial being an unfair trial, and by modern times. But now, do you hear anything like that from the NGOs and human rights groups about fair trials? You don't. I have to say, I remember when I started the Kenyatta case at the ICC, I complained about a press release from one of the very key supporters of the court, that it was so one-sided. And they wrote back to me saying, we will bear in mind your comments. They weren't going to change them, but it was a one-sided episode. Margaret, you were really, I think, from your opening statement, looking at things very carefully in relation to justice. What would you say about the influence of NGOs?
So it's interesting. I think that we have to keep in mind that courts are inherently expressive institutions. So there are going to be narratives that emerge around the work of any court. And what Mark was saying about the positive aspects of having sort of outside civil society, that is to say, I took that to mean anyway, global civil society having an input into the development of the narrative, particularly through amicus curiae briefs, I think raises for me the question that I think, again, is very much underdeveloped in international criminal law about who the main audiences are for the expression that international criminal law engages in. And in particular, I think that the regime is still divided between some folks who want to focus on global audiences, global civil society, states, but looking at the ICC, for example, as an institution that is intended to speak to the world, and others who view international criminal law and particularly institutions like hybrid tribunals, but even the ICC, as more aimed at the victims of the particular crimes that the institutions adjudicate. And I think that that tension between those audiences is at the heart of some of the real problems in international criminal law, including the sort of failure to really understand what kind of justice it ought to be delivering, and even to the point of thinking about defendants' rights and fair trials. If the main audience for a case is the community where the crimes were committed, then perhaps that community's understandings of justice and fair trials ought to be the one that is taken into account. I was actually working on the Tadic case in '97, and that institution was very much conceived of at the inception, as you say, as sort of as taking up the legacy of Nuremberg. And I think the focus was very much global. It wasn't on, what are the norms in former Yugoslavia and how can we take those into account in ensuring justice and fair trial standards. So I think that this question of narrative, we have to think about whose narrative, who ought to be influencing the narrative, and think about that in terms of the purposes that these institutions are really intended to serve. And I think those questions are still really unanswered at a theoretical level.
Yes, thank you. Mark, can I just raise this with you, because there's a question from Sarah Dill about fake news and mentioning the recent election in America and the stolen election and the fraudulent election. Well, we've had that in international criminal law. That was part of the backdrop to the Kenya case, was the so-called stolen election, and pleaded by one side, which had been taken up and copied from Ukraine, and where it had come to the fore and caused the deposing of a president that certain parties didn't like. Mark, is it dangerous having these days so much concentration upon a narrative, given our what we face with social media?
Well, I don't think so. I think the narrative is extremely important. I think it's challenging, as we've been discussing here, but a narrative that is objective, that's based on facts, evidence, is exactly what I think is part of the responsibility of international justice, is to express and define what that narrative is based on truth. Where we've had a real challenge is the disconnect between international justice that is being portrayed by tribunals and the perception of justice in what Meg was talking about, the purpose. If the purpose is to have a better understanding in the area of the conflict, so that the tribunal's work can help define a narrative that everyone can accept as truth. That is a disconnect, because we haven't seen that. We didn't see that with the ICTY in relation to the former Yugoslavia, particularly in Serbia. The views of the Serbian population in regards to what was coming out of the CTY was completely different from what I or others might perceive as being objective truth. But there was a difference. The pendulum started swinging when if you remember the videos that came out, the filming that came out of the massacre in Srebrenica and elsewhere, that hard evidence started shifting the narrative in the eyes of the population in Serbia. So it's a real challenge on this. Stephen, I wanted to say one thing about the fair trial, and it got back to the Tadic trial, and it was a visit I made to Justice Goldstone before the Tadic trial was even starting. I was there, as you mentioned, about for the American Bar Association, saying to Justice Goldstone, we, the American Bar Association, would like to assist you in prosecuting this first case since Nuremberg. And it was an hour-long conversation. And in the end, he said, Mark, I appreciate your visit here, but I want you to help the defense. And he said, I'll never forget this, the yardstick measurement of this case is not whether Mr. Tadic is found guilty, but whether he's perceived to have had a fair trial. And I'm worried that the defense does not have the resources. Could you help in that way? That I thought was remarkable, and that led to everything that followed, Stephen. So the idea that the prosecutor had his focus on ensuring that the trial itself would be fair was, I think, quite remarkable and indicative of who Justice Goldstone is.
Absolutely, a remarkable man and a very good prosecutor as well, and how he ran the institution was exemplary. Just looking at Bill, at what Mark said, how far does the narrative take us away from evidence? That's what I'd like your perspective upon, and what examples there might be, because the narrative can in fact cause the story itself to be the thing that is supported rather than the evidence.
Well, we have, crimes that are being prosecuted and that are being shoehorned into this narrative, this narrative of a conflict, and that's inevitably, and I think you've made the point, and I think Meg de Guzman made the point as well, that it may inevitably have consequences about how rigorous the evidence is being, the assessment of the evidence. There's also, of course, the willingness of courts and tribunals to be, I don't know if maybe rely is too strong a word, but we have a lot of supplementary materials, reports from NGO documents and commissions of inquiry from the United Nations that influence as well the evidence and how it's perceived. Of course, we have to hope that we need judges who are fair, and we generally have that, and we need defense lawyers who are competent and are able to pick this all apart as well, and to hold them to the standard. As I say, I think, you mentioned Richard Goldstone. I was reading something he published very recently, talking about the acquittals at the International Criminal Court, and repeating what he told Mark years and years ago, almost a quarter of a century ago, that there's nothing wrong with acquittals. But that narrative, I mean, it also relates to something. When we go to the case law of a body like the European Court of Human Rights, we find the sensitivity to how, not a narrative exactly, if they're not using that term, but how the political discussion and statements about criminal activity can encroach upon the presumption of innocence, and thereby also influence the trial. But it's very difficult. It's very difficult to identify that and to extract those factors. And it takes judges, I think, with the courage to say, that narrative, set it aside. But then they're being told that this is about doing collective justice in a way, that what the role of the tribunal is to do justice for an amorphous body of victims. And that means that the narrative is going to be influential in directing how they perceive the role of the trial, which is more than simply determining the guilt or innocence of a specific individual in a precisely defined case.
Yeah, I was once asked a question, you must read a lot before each case you take. You must read all the reports about it and all the history books. And I surprised the journalist by saying, no, I don't read any of them. To be frank, I just look at the evidence, because I know people who read those reports and they lose sight of the evidence and they think that the truth is in the reports or some book. Meg, I'd like your perspective upon this, because the narrative can cause confirmation bias, couldn't it? Isn't that a danger?
Yes, absolutely. I think that's a real danger. And I think, I'm sure that happens in courts around the world, international courts and otherwise. But I also think that, as I said before, narratives developing is inevitable. And so to me, it's not a question of, is it good or bad that there's narrative? It's a question of who ought to be influencing the narrative and how. And are they doing it in a way that is cognizant of the ultimate aims of international criminal justice? So Bill raised the issue of, the idea that the aim is some kind of justice for the victims. And I think that's a very powerful aspect of the narrative that can sometimes lead to shortcuts and other approaches to the law that run the risk of undermining defendants' rights. And so then it's important that other players in the system stand up for and sort of steer the narrative in a way that, that focuses on defendants' rights to sort of counter that. So somebody in the chat was also asking an interesting question about the ICC. Is it one narrative or is it multiple narratives that evolve at the ICC? And I think, and in particular, whether the different organs of the court build different narratives. And I think they do, right? I think that there's a narrative that is built by defense counsel and by, the victims' counsels, and then also by the prosecution. And those narratives are in conversation with one another. And that's a good thing. The danger comes when there's just a really dominant narrative, sometimes from the outside, that doesn't leave space for that contestation of narratives. And that's when I think it becomes dangerous in terms of defendants' rights. But if we have, multiple organs of an institution, as well as, outside players, civil society, victims' rights advocates, and so on, all contributing to contested narratives that are in conversation with one another, then that is probably the best we can do to try and ensure fair trials.
Yes, we haven't talked about the historical importance of these trials particularly. Mark, when we first went to The Hague, I always remember that there was a big discussion about the filming of the trials, as well as the archiving of the trials, and they were to create a record in the same way that Nuremberg had a record and an archive. Is that kind of historical quotient something that puts too much pressure upon the business of the court, which is to do justice? Does that seeking to have this place in history?
I think many would argue that it does, and they wouldn't see that the court's primary or even a within the top 5 of the responsibilities the court has or focus should be on that type of historical lessons or the history being created. I happen to be probably in the minority. I think that is part of what the court should be doing. I recognize it's a bit of a challenge, but to me, this gets back to the narrative. If you're able to create a narrative based on the evidence, based on the facts, based on the advocacy that comes from 2 parties that's then determined by the court, that should stand. That won't be the entire narrative, but it's an important narrative to have. Will it shift the views of those in the conflict arena? Jennifer puts in the chat about that, what happens if the ICTY's narrative is completely different and the domestic narrative never gets there, never gets to that type of recognition. And I think that's part of the challenge. But the fact is, in the early stages of international criminal law with the tribunals, the idea of outreach was never really a paramount issue. Certainly it was not with the ICTY. But I'll say that right now, with any tribunal that has come on, including the ICC, outreach is an important part, not only for the general public, but specifically for those that are in the arena where the conflict occurred. So I think that's part of it, and determining the history is also part of the responsibility.
Bill, you're the biggest historian I know in the subject that we're talking about. You devour the history books and old records and go back to original sources. Do you think too much history, though, is good for justice? Mark's come in with a view there that he thinks it's important because it's part of the outreach and to explain to people. But does this put a pressure on justice?
Well, of course, history is constantly being reassessed and rewritten. So what we're talking about when we talk about a narrative are people, in effect, manufacturing a version of history that may or may not be sustainable. And we know that there are interpretations and ideas about history that evolve and change. I mentioned that going back to the First World War, where the assumption was that Kaiser Wilhelm had started the war. But finally, when they looked more closely at it, it wasn't quite so obvious about it. You know, I think that maybe one of the things we haven't really turned our attention to too much in this discussion is that in cases, and we could talk about the cases that are before the ICC at the present, you have cases where there are 2 different narratives. So we have this ongoing situation in Palestine, which is before now before the pretrial chamber, and we're waiting for a ruling on this territorial issue. And as you know, there have been 50 or 60 amici curiae that are not entirely on the same wavelength. Am I understating the situation there? Different narratives, indeed. And somebody at some point is going to have to take a decision if this goes forward, whether the prosecution will be about firing rockets from Gaza into Israel, or whether it will be about building settlements in the West Bank. That's a narrative about a conflict. We have, if you go on the website of the court, you'll see the 2 in the preliminary examinations, Venezuela 1 and Venezuela 2. They're both about the same reality, which is the suffering of the people of Venezuela. One of them says it's the responsibility of the government in power in Venezuela. The other says it's a result of the sanctions imposed by the United States and its allies. Those are very different narratives about the conflict, and there are different publics who support them as well. And it's going to be, I mean, I guess we'll know, I think the king is going to be crowned next Monday, we think, of the ICC, the new prosecutor. But somebody has to adjudicate those narratives, that way of looking at the conflict, at looking at the situation. And it's going to, and there's no correct answer because we're divided on how we see this. We're not on the same wavelength. We're divided about how we view the situation in the Middle East, how we view the situation in Venezuela and elsewhere. And we could look at Afghanistan as well. And we see this even in the preliminary, even in the reports of the prosecutor. Is Afghanistan mainly about torture by US agents, or is it about atrocities by the Taliban? That's narrative.
Meg, do you think the international courts and tribunals have succeeded at all in trying to produce an accurate historical record, as they are aware, the judges are aware, the court is aware that there are competing views as to what started a conflict, how a conflict started, or at least there emerge competing views. Sometimes I've noticed in some cases, it's all been one way until the direction, the evidence changes it. Do you think they've been successful in their bid to define history? Or the historical?
No, I think, yeah, I think they have played a part. I don't know how one would measure success in order to answer that question. I think some have been more cognizant of that part of their role than others. So the Special Court for Sierra Leone, I think, rightly gets some credit for the way in which the prosecutorial selection decisions showed the role of various parties in the conflict, and that was probably an important thing for that institution to do in order to contribute to the historical record. You know, the ICTR gets criticized for only having prosecuted, you know, one side when the government was also engaging in atrocities. And I think that whether that was the right thing to do or not is actually a more difficult question than it is sometimes made out to be, because the court was focusing on what it saw as the main narrative, right? The genocide was the main narrative. And yet by not prosecuting those in power, the court also lost some credibility with many audiences. So I think, again, it gets back, for me, it gets back to the question of what are the goals of the institution and when they come into conflict. So one of the goals might be to contribute to the historical narrative, but that goal might come into conflict with a goal of, for example, Ken Gallant in the chat has raised the issue of deterrence. And maybe an institution is also thinking about what are the most important crimes to deter right now. And so, for example, when the Special Court for Sierra Leone and now the ICC have focused on child soldiers, is that because it's such an important part of the historical narrative? Maybe. Is it because those are the worst, you know, recruiting and using child soldiers are the worst crimes happening in those conflicts? Arguable. But is it very, very important to be deterring the use of child soldiers, not just in those conflicts, but around the world? Absolutely. And is that a very legitimate reason to make those selection decisions? I think so, even though it sort of maybe paints a very partial picture of the conflict. There are other goals that have to be balanced. So I think one of the other things that I just wanted to point out here is the importance, and I think Bill's point about Gaza and the ICC raises this as well, the important role that prosecutorial selection decisions play in painting the narrative, right? What the prosecutor selects is what then is front and center. And if other players want to have a role in shaping the narrative, they have to really work either with or against that narrative. It sort of becomes dominant.
Yeah, there's a question we've got here from Sarah Kay, no relation for you, Meg, which I'll just put to you and I'll read it out. Is the legal narrative the only one that should be elevated, or can we accept to have a different, if not outright contesting one, due to the fact that admissible evidence can't possibly be the whole picture, especially in conflict?
Yeah, thank you for that, Sarah. I very much agree that the legal narrative can't be the only one, and that it's important for these institutions to be humble and to be forthright about what they can accomplish. And I think to a significant degree that, the ICC has been pretty good at this in their public relations efforts, to say, look, we are pursuing a particular defendant for particular crimes based on very specific evidence. And this is not going to represent everything that happened in the conflict. Here are the reasons why we are choosing to pursue this particular person for this particular crime. But everybody should keep in mind that there's a lot more happening here than a court can capture in a handful of cases, which is all we have the resources to pursue. So I think it's very important to have other, and actually I'm hosting somebody next week who's talking about the over-criminalization in this area. I think that's something to keep in mind too. It may be that we should pay more attention to truth commissions again, to other modalities, to traditional justice mechanisms, so that there are other bodies also seeking to tell the stories, to contribute to the narratives.
Yeah, Bill, perhaps I can address this follow-up question from Sarah Kays. The role of legacy projects in regards to cementing challenging narratives in international criminal justice. Legacy projects, Bill, what do you think about them?
Well, legacy projects are in a way as good as the narrative that emerges from the tribunal. So that to the extent there are issues that are resolved, the legacy project is going to ensure that that's respected. I was reminded of something that Michael Ignatieff said many years ago, I think speaking about truth commissions, but I think it's just as apropos with regard to international criminal tribunals. He said they may not be able to get to the whole truth, but they can put some of the lies out of commission. And that's very important when we live in a world also where we talk about denial, about people, and we know that we have encountered this for decades now with denial about the genocide of the Nazi genocide committed during the Second World War, and how important that is, and how that we continue to have to fight that. Even in recent weeks, the reports of these fanatics who were demonstrating for Trump in Washington in early January are deniers. There's lots of documentary support about that. So this is where the Nuremberg judgment and the Eichmann judgment and some of the others are so important in saying, listen, all that evidence, and this is the other part that the tribunals do, is they create a substrate of evidence that's also going to remain, and that historians may be consulting and reviewing and analyzing for eternity in a way. So, I think if we're more modest in our ambitions about tribunals, and we say, can they put some lies out of commission? People who deny the atrocities, the genocide committed at Srebrenica in 1995, that's done. We have the judgments, we have the evidence, that's clear. Nobody can challenge that. And I could give many other examples, the Rwandan genocide, things where there are questions about it. Meg says, and I agree with Meg about this, I think that we can oversimplify how the International Criminal Tribunal for Rwanda should have dealt with the crimes perpetrated by those on the other side, the so-called RPF crimes. But one thing is for sure, that the atrocities committed against the Tutsi minority are beyond dispute now. And we can see that, we can even see that in the willingness of legislators in many European countries, for example, to define crimes of denial and hate propaganda with regard to the Nuremberg judgment as a source, as an authority. And perhaps in the future, if denial of Srebrenica or denial of the Rwandan genocide or other atrocities becomes an issue in the future, those judgments are going to be there, and the evidence that they heard is going to be decisive, and it will be eternal.
Yes, Mark, do you think
Well-
Truth and Reconciliation commissions get to the evidence in the same way as a court does?
I would say no. I would say in the Truth and Reconciliation process, you're getting much more towards a shared narrative, and I think that has great merit to it. So I lean in that direction for that reason, but I want to reiterate that, and I think Bill's just made the crucial point here for me, and that is whether or not, again, there's a narrative that comes out of judgments from courts. Whether we like it or not, there has to be. If we're not accepting the fact that a judgment coming out of the court is not part of the narrative, whether or not it's accepted or not, then for me, we've got a bit of an issue. It is a narrative. It will be part of the historical documentation that occurs, even if the court is not primarily focused on that. I think that's important. I think that's very crucial. It may not suggest a shift quickly enough, particularly for those that were part of the conflict. They will still debate the nuances. They may even debate the whole issue. They may accept the denial part of this. I don't know. But I think it goes a long way to ensure that there is an historical record, and it's based on truth, it's based on evidence, and eventually that cannot be denied. And that I think is absolutely essential.
Taking up a question or a point from Eva Vukusic here, Bill, you speak a lot to international judges, and you're able to discuss their jobs and their work with them. Do you think they're comfortable making findings about history when they have to in a judgment, in a way, when they have to refer to the context in a particular way? Do you think they find that easy?
I think it probably depends on the individual judge, Stephen. I think judges do from time to time express their own discomfort, as you say, about doing this, just as prosecutors and defense counsel do as well on both sides. They are constantly, if this was a conference of prosecutors or if it was a seminar of defense counsel, I think they'd all be saying, don't make us do this. This isn't our job. We have a very, but as Mark Ellis has just said, it's inescapable. That goes with the territory. I think that there are lawyers, again, defense counsel and prosecutors, who also understand that they are part of a historical process, and they enjoy isn't the right word, but they thrive in that environment. And I think there are judges as well. I think there must be judges who are very, very conscious of their the fact that they are making, that their decisions are historically significant. Whether they want to admit that or not, maybe some of them feel that it's a bit, too egotistical to admit that you have that ambition. But it's like anybody participating in a historic process, just like you and me and others, we might do something entirely minimal in terms of our personal involvement, like participate in an event, go to a demonstration or a parade, and we'll tell our grandchildren that we were there. And we think that we contributed to history. I'm sure judges do that too. I have no doubt that Robert Jackson and Jeffrey Lawrence and the rock stars of the Nuremberg trial, they were aware that they were part of history and that they were making history as well as identifying it.
I think Sir Norman Burkitt certainly did, and he was only, of course, the deputy British judge, but he claimed writing the entire judgment, and many thought he was on the bench during the trial, but of course he wasn't. Luckily, he's still not sitting today, as he'd probably take me to task. Meg, there's a very good point from Amber Pierce, and you were there at the time, I remember, in the Tardich trial. Witness number 5 was Professor Gow from King's College, London. There was a few early witnesses who didn't give evidence about very much other than crimes that were happening, and no one could really see where that evidence was taking us. But Professor Gao came in, and as I recollect, it gave evidence for over a week. That was enormously controversial, and the criticisms from various parties and factions, even from Serbs or Bosnians or Croats, all parties in relation to what he said as a historian, as an expert, trying to define for the judges what it was about and what the history was. Was that a good thing to have done, do you think, in looking back at that trial?
So it's a very interesting question, and not one that I have considered with respect to that trial in particular. In general, I would say that it gets back to the particular audience that the institution is seeking to reach, and how the trial is framed, and how the narrative that the court wishes to contribute to is framed, is going to influence the extent to which they want to bring in, and the particular experts that are appropriate to bring in. And so I think it is important to be very careful, particularly for an institution that is torn between seeking to contribute to a global narrative and to particular goals of the society most affected by the crimes. In that kind of a situation, the institution has to be very careful to bring in experts that are going to be received positively and productively by those audiences that are important to the institution's goals. And again, there may be a tension there. There may be conflict where the expert, and this may be what you're sort of referencing in regard to what happened at the ICTY, that the expert is very much able to speak to the narrative that a global civil society sees emerging from the institution, but much less able to do so with regard to the local communities most affected by the crimes. And that's a real tension and a real question of most appropriate goals that institutions need to be, I think, more attentive to than they have thus far. And sort of thinking about bringing in experts in terms of what are the goals and how will this expert seek to contribute to those goals, and particularly when they're in tension. I can't resist saying that I saw at some point anyway that Ted Marone was on the call, and I think is somebody who has contributed tremendously to narratives, and that there are many people who have contributed in very, very fundamental ways, right, beyond going to protests. I think we have to recognize those roles. Anyway, that's not directly responsive to your question, but I was just happy to see him there.
I must confess to letting Professor Gao go, in the sense I didn't object, and I think that was because we had our own expert witness, and I might have been prevailed upon by other members in the team not to take that point. But there was a Scandinavian judge who followed him called Hans-Sophie Grev. She may have been a Swedish judge. Anyway, she had been specially commissioned by the UN to go into Bosnia and the Prijedor area in particular, which was the setting of the Tadic case. And I objected to her evidence. As I said, it was full of hearsay. She'd not been there at the time. She just reported what everyone else has told her, and she doesn't know whether it's true. And made my objection, and lasted 5 minutes with Judge MacDonald, kicked out as yet another obstructive objection from the defense. But that's all right. We grew to like each other. But to me, it was, what is this about? We're meant to be trying a man who was in a place at a time, and yet we're talking about this obviously very distinguished judge telling what everybody else told her and putting it into a UN report. And I felt that was prejudicial. I felt that was building up the wall of sound around the court. And there were a lot of people I know wrote afterwards saying that that was the right thing to do. What do you think?
Could I say something on that? Yeah, I want to say I agree. The idea that you were going to come in and create a shared historical narrative about the former Yugoslavia is a big ask. I lived in the region before the war for 3 years. The sense that you would have agreed upon history of 100 different issues is a bit naive. You won't have it. So I would get back to Meg's point. If that had an impact, did it have any effect on the results of the trial, that attempt to set out what he would have thought was an objective history, where in fact I don't think it's possible, that would be a problem. However, although there wouldn't be a shared narrative on the history of the conflict, there could be in time a shared acceptance of the evidence and of what occurred in the wars in the former Yugoslavia based on the findings of the court. That to me is the narrative that I think is important to carry on. And that could be the new shared understanding in the region because of the results, because of the work of the court.
Yeah, Bill, what about you in your, as an observer of these trials over the 25 years, these reports that come about like Hans-Sophie Greb's, which I objected to. I felt it unbalanced the case, and it wasn't based on the witnesses' direct evidence. What do you think about that?
Well, we have many examples of the reports by UN mechanisms of various kinds, and and also from NGO reports. I'm reminded when you speak about the historians of the former Yugoslavia about the other side, Rwanda, the other tribunal. I went first to Rwanda in 1993, more than a year before the genocide, as part of an NGO fact-finding mission. And my colleague there was Alison Desforges, who you may have come across. You did the Musema case at the,
yeah.
I expect she was an expert witness. She was a historian at the university in Buffalo, and she had her own vision of Rwanda. And called as a historian, she really just had opinions about the current situation in Rwanda, and no doubt, I think had a great influence on the judges there and in the development of the narrative. Now, I'm not suggesting that it's a false narrative. I think she contributed greatly, but probably it was a mix of evidence. You know, when we talk about evidence at a court of law, you know, we're all very attuned to the danger of convicting people who didn't commit the crime, who are innocent, or where there's not enough evidence. And Meg said this at the very beginning, that when we start to get these more informal mechanisms in there, who have another role, they have a different role. When I did this mission in Rwanda, and I've done other fact-finding missions, where we were always saying, let's save the evidence for prosecution. You know, we'll keep the evidence, it can be used in a prosecution. Of course, it never is. And there was the famous commission, the Bassiouni Commission, about the former Yugoslavia, and it really had, I think there was this idea that all that evidence would then just be given to the ICTY and they would convict people on the basis of it. But that didn't work. And now we're in this new generation of experiments about this, these sort of, where we have the Human Rights Council setting up basically an investigative commission gathering evidence to prosecute international crimes. And it's a different role. Normally, what we want from the Human Rights Council and from special rapporteurs and bodies like that, they're there to sound the alarm. They're there to alert public opinion at a political level. And once we blend them with the idea that they're also collecting evidence to be used in a court, we get into very dangerous ground because they're fulfilling a different purpose. They're applying different standards of evidence. They're relying on hearsay evidence because they're there to get people to move on an issue, not to throw an individual human being, to deprive them of their liberty and convict them of a serious crime. That's where that material is I think particularly dangerous. I think asking that the background narrative is going to be established using other types of sources of evidence, including expert evidence, which ultimately is opinion evidence. And as you know, as a courtroom lawyer, if you can get an expert to say one thing, you could probably find an expert to say the opposite. You know,
Yeah. Well, we did. We found another expert to say the opposite to Professor Gow, that I don't think he features much in the credits of the judgment of the Tardich case at the ICTY. Meg, I don't think the international courts and tribunals now are relying on NGO reports. They were there in the early days, but the judges now are much more evidence-based, aren't they? In fact, I don't think they're even attempted to be put into evidence now. It used to be when we first started, there'd be a whole raft of reports dumped on the judge's desk, and you stand up and object, and the judges will say, well, we'll pay what regard we should to the meaning. We're not going to read all those reports. Am I right about that?
I think that's right. I think that the whole regime has professionalized in various ways, and that's probably an example of that. I think judges, Nancy Combs wrote a very good critical book about evidence, unreliable evidence coming in, particularly before the ICTY and ICTR, and maybe I think there was one other one in there. And I think that, criticisms of some of the early work have led to more rigorous evidentiary standards being adopted. I also think it's important to keep in mind the difference between civil and common law systems in this regard, and that, civil law systems tend to let in a great deal more evidence because they don't have juries. And these tribunals are seeking, for the most part, to blend these systems without really having adopted a philosophical position around how the blend is to be done. And so when evidence comes in that in a common law system might be considered unreliable and prejudicial and so on, the standard would be significantly looser in a system where professional judges are believed to be able to, discern what parts of the evidence they ought to take into account in making their determination, and what parts to sort of leave aside in ways that juries should not. So I think that's part of what's going on here as well.
Well, I could talk all night with the three of you, and I don't know whether everyone would remain listening, but I found this a very good evening. We have to wind up now, as we've been going an hour and 20 minutes. And it was a great pleasure for me to meet the three of you again, virtually. One day we will meet again and be able to have that cup of coffee at a conference and a chat. One of the reasons why I chose this title, and I mentioned it to Bill earlier today, was in 2011, we had this discussion about the narrative when we were in Salzburg, and we were both appearing for dear old Otto Tripfer's Salzburg Law School, and we were there at the same time and had a chat about the influence of the narrative. And I thought it would be a good one to kick off our series with. And I must draw a line on it now as we've got staff to go home and that kind of thing. Well, no, they are at home. But Mark, thank you very much.
Thank you, Stephen.
Great talking to you.
Thank you.
Meg, thank you very much in Philadelphia there. Great
Thank you,
talking to
Sue.
you. And Bill, great to see you again. And I'd like to present the thanks of 9 Bedford Row for you joining me this evening. And I hope our listeners enjoyed it as much as I have done. Thank you very much.
Right. Thank you, Stephen.
Bye-bye.
Cheers. Bye.
Bye, Ted.
Bye.
Bye, everyone.